right? So those are facts that occurred, but that the district judge didn't consider because she apparently viewed them as out of time, that this had occurred. Are those not facts that are relevant to just for the president to determine the threat and whether there's a threat to DHS being able to enforce the 400 laws it's tasked with enforcing? I mean, they couldn't operate a facility. I don't know that ever happened in LA. There were attempts to breach a facility. Here, a facility was actually closed for almost a month. And the record includes more than one, at least 2 attempts to burn the building down and vandalizing the building so that it's difficult for the officers to move in and out of the building and increases danger. And the building is now currently boarded up, and the city has told DHS they have to remove the boards. So that means the facility presumably will be inoperable again. So why is all of that irrelevant to the president's decision to federalize the National Guard?
Well, I'd like to push back a little bit on the reframing here. What we have is in early June, the facility was closed for 2 weeks.
During specific dates, June 13th through July 7th. That is not 2 weeks. It's about 3.5. And I think it's properly characterized as nearly a month. But the facility was indeed closed, but the district judge didn't consider it because it was in June. So if I understand your position, only things that happen like September 24th, 25th, 26th, I mean, a very small window of time, those are the only days that the president could have legally considered when deciding whether there was a threat to the enforcement of law?
Well, if we're talking about the third prong, the inability to execute laws with the regular forces, that is a current temporal requirement.
Okay, so what is your basis for saying that? Because I didn't see the Newsome, but what is it, where is it that it says there's a they talked about the facts there, which happened to include events that had occurred in the preceding days. Here, the president relied on, according to the declarations that have been presented, on the facts leading up to the order from June, July, and August and September. So there's a period of a few months where things were unfolding on the ground. And what I think you're saying is we can't consider any of that it should only be a few days. But what is your basis for saying that?
The text of the statute is the basis. So if we look at the third prong, it says the president is unable. That is a current inability to execute with the regular forces the laws of the United States.
And is that a day by day? So that, I mean, if we said forces are allowed, and then what, we come back the next day and say, oh, well, you got it under control. Now they're not allowed. Then it goes back up. Oh, they're allowed. I mean, it just seems like such a tortured reading of the statute. I mean, I'm not even sure President Lincoln would have been able to bring in forces when he did, because he'd have to wait. You know, if he didn't do it immediately after Fort Sumter, your argument would be, oh, things are okay right now. It just seems.
What is the effect of the June 7th authorizations statement that the National Guard should be performing federal functions at locations where protests against these functions are occurring or likely to occur based on current threat assessments? So does that limit how we or how Secretary Hegseth would have had to consider what was currently appropriate?
Yes, if the June 7th memorandum is part of this court's evaluation of the president's determination, it is limited by the current situations. And I would also, again, just direct this court back to the text of the statute, which there is an expectation that the circumstances are going to be evaluated as they happen. And that makes sense because these are emergencies, these are unusual circumstances that would immediately require the president's attention and response. If these are circumstances that are so significant that they could challenge kind of the fabric of our nation, the threat of invasion, they need an immediate response. And there isn't an attempt to penalize the president for waiting. There is a requirement that the circumstances as they happen be so significant that we need to federalize the National Guard. And
actually, for number 3, I don't think that's true, For 3, it says the president with regular forces can't execute the laws. I mean, I'm sort of trying to figure out how a district court of any nature is supposed to get in and question whether the president's assessment of executing the laws is right or wrong.
Well, this court has already concluded that there is judicial review of that
I
determination.
understand that, but it's also great deference. And I mean, here, it has to be colorable. And so when the president comes in and says, look, we've got 115 FPS forces that aren't normally in Portland and we've had to move them, this is straining our ability to execute the laws. I don't understand how you can question the behind the scenes to say, oh, no, that can't be right. I mean, we don't have a view into what laws are trying to be executed or how they're being impinged. But why isn't that colorable?
Because it's not true. Unfortunately,
It's not true that 115 FPS forces have been there since it reopened in July?
Well, we do have in the record that a lot of the surge forces were returned before the president's announcement. So I understand that these declarations kind of, they discuss the worst of the circumstances, which I understand, but they're also written by supervisors who don't work in Portland. They're from outside of the state.
I have absolutely no idea. The district court said the same thing. I have absolutely no idea what that has to do with anything.
Because we would direct.
You want to focus on what's going on outside and it doesn't rise to this level. But that's not what the statute says. The statute says the president can't execute the laws. That's an internal decision making. And whether there's a ton of protests or low protests, they can still have an impact on his ability to execute the laws.
But this court has said that minimal interference isn't enough to raise to the level of an inability to execute laws. And that's what we have here. We have, yes, in June, there were more intense protests, but we have the district court identifying that the normal forces were able to manage those protests, which is within the job responsibilities of FPS generally. This is what we do. They do. You have from the declaration.
But that just seems to be the wrong analysis. And the district court did this. The district court said, well, look, people who acted violently were arrested, so everything's good. But that's not what the statute says. The statute says the president can't execute the laws. And I'm just trying to figure out why we're giving, district courts the ability to say, well, this is what I see on the outside, so therefore I'm going to transfer that onto what's going on behind the scenes. And we have declarations that say that it is impeding their ability to perform their function.
We have declarations that say we're short-staffed. We're having administrative difficulties because we don't have enough people. That is not a reason to bring the military into the streets of Portland or any other city in the United States. There needs to be something more than a deficit of employees to raise to the level of such a significant incursion into the sovereignty of a state. It needs to be more, and this is the case.
Into the streets, the deployment is limited just to the protection of federal personnel and federal property. So I saw quite a bit of that language in the motions suggesting that National Guard members would be deployed to patrol the streets of Portland, which is, I don't think the government has ever said that is the intent. The idea is to protect the building so that can remain open. But federal personnel. But
what we do have, though, is a history of a very expansive and almost strained reading from the government of the district court orders. And it would, because this authorization is to protect any federal government location, any federal personnel go throughout the city to execute whatever their mission is. And there's no, as of the drafting, there's no specific limitation that they're going to only be in.
But why would we enjoin it up front? I mean, I want to be clear. I'm very sensitive to the slippery slope argument that's being made here and the slippery slope argument that's being made in LA and around the country. This is something that, clearly the founders were concerned about. there's been a lot of debate about how this should be used. So I'm not trying to diminish that. It may well be that the forces are used in an improper way, but we don't have any evidence of that right now. All we have is a document that says we have a federal facility under attack, or that violence has been, forced it to close down, and we want to protect it. That doesn't strike me as a glaring overuse on its face. Now, if what happens is what you're suggesting, that they do engage in law enforcement activities, then obviously we have another problem. But that's not even what the district court found. I mean, you couldn't find it. There's no deployment at this point.
Well, certainly. I mean, we're not talking about like the violations of the Posse Comitatus Act at this point. It is a bit speculative. But what we have is, from Newsom, we know that this court has a role in evaluating the president's determinations. There is a direction that is this court's role. This is the case, though, that represents the outer limits of the president's authorities. We have, in the month leading up, not even the week, if we look at the entire month of September, the district court found there was one instance in the kind of the weeks leading up where protesters shined flashlights in the eyes of drivers. There was also,
I mean, if that's true, then I think we've got a problem, because I don't think that's what the record says. I mean, if the district court really said that's all that happened in September, then the district court's clearly erroneous. I didn't think the district court said that. I thought the district court actually detailed more than just one incident in September where flashlights were shined in the eyes.
Well, Your Honor, that's the record, though. Even if we go back to...
Well, we'll have to go into it, but I don't understand the record to be that for September. I understand it to have gone down, but not that there was one incident and that was it.
That's not us saying. There were certainly protests throughout the month of September, but they were, as I earlier mentioned, and the district court found, small, less than 30 people, largely sedate, generally peaceful. That's what was happening in September. So there was an incident on Labor Day on September 1st where there were increased protests. 125 people were involved in the activity. But what we have is the statement from FPS that they were not concerned with the group. That's at 46-1. This is the day when the guillotine was displayed.
Right.
But that's arguably protected political speech. There were 40 people who remained after the larger group left, and they did arrest a few. After that, you have September 2nd, completely uneventful. September 3rd, there was a drone flying. There was some altercations. Everything was managed. That's the consistency throughout the month of September. And there were occasions when there might be, a larger number of protesters, but they were generally calm and sedate. And any of the sporadic and kind of more minimal criminal activity was appropriately handled by law enforcement resources. And that's what's supposed to happen, because the situations that we're talking about, even the situations where it unfortunately could include an assault on a federal officer, that's a crime. That's a crime that was handled. They were arrested, and I understand that the U.S. Attorney's Office had 22, they're prosecuting 22 defendants. That's how this process is supposed to work. It's not that there is a protest, and then you just send in the military. This is protected speech. And for the most part, it is calm and sedate. And it is
so the drone on, I guess this is the Wednesday, the suspect got violent and spit on agents. He was arrested and booked.
That's general criminal activity that's handled appropriately by law enforcement. On the 4th, you have 20 protesters, and then there's only 15 at 8:30. On the 5th, FPS said it was a small group with low energy, no calls for service. On the 6th, there was 50 to 60 active protesters, lots of noise. They were energized, no arrests. September 7th, 7 people, low energy. September 8th, 30 people. There were an altercation between protester and a counter protester, not against the facility. It continues, and I'm happy to go through the record.
No, this is helpful. We'll have to go through it. I mean, I don't think there's any question that it's gone down in September, but part of the problem there is it's gone down largely because of this influx of other forces, which is outside of the regular use of those FPS officials. So
does the
it's sort of
record
hard to
show
do
us
that.
how many of the extra people remain in Portland, the FPS, and how many have been sent back to?
I don't know if you heard the question. I think it was, does it show? I mean, we know that up to 115 came. Do we know how many were there of the extra FPS? Maybe this is for the.
Or something. Did you not hear?
Yeah, we're not hearing you very well. It's kind of getting muffled for some reason.
Well,
There you go.
Okay,
There you go.
I'm right by the microphone. Does the record show? The record is in front of us. How many of the FPS officers from outside of Portland who came in remain in Portland now, and how many have been sent back to somewhere else?
I haven't been able to find the exact numbers, and much of the declarations don't have dates associated with them. So it is also very possible that those officers were sent in June and they have all returned. We have a note within the last week before the president's announcement that there was a surge of officers that came out, and then there was no responsive protest activity. And so they went back to their respective offices. And then even after, I think that they may have plussed up their numbers in anticipation of the president's announcement. But then even then there was some increased protest activity, but it went back down. And
so the answer seems to be you don't know, from that we can't know from this record. And I believe counsel on the other side said, well, they haven't all gone home, but I understood him to be saying indirectly that some or many have gone somewhere else.
certainly a lot of them have gone. And what we also know from one of the declarations is that FPS, they respond to even nonviolent protests. This is their job. They respond to potential threats, and they would use those numbers of officers to go to any kind of that exercise of speech, just in case something becomes violent. So this is squarely within their area of responsibility. And I know we continue to talk about FPS, but we haven't even talked about any of the other federal officers that are at the president's disposal. We have a ton of law enforcement agencies under the president's control. There's referencing in their declarations to circumstances, again, that are outside of what happened in Oregon, or even if there was potentially a bomb threat. Well, we don't have anything that connects the bomb threat to these protesters. And if you do, you have significant law enforcement resources, ATF, FBI, that can respond to those potential threats. That's their job. That's what they do.
The problem that I have with this argument that I'm just trying to struggle with is, the president gets to direct his resources as he deems fit. And it just seems a little counterintuitive to me that the city of Portland can come in and say, no, you need to do it differently. Now, I understand there's a statute here, and we're going to have to review that. But this goes to the level of deference that I think the president is entitled to in these circumstances. And it's not all driven. Would you agree? It's not all driven by what we see on the streets. It's also driven to some degree by what's going on behind the scenes. And you don't have a full view into that.
I acknowledge that there is certainly information behind the scenes, but we don't have that in this record, and we don't have the defendants coming forward and putting forth anything that shows that the sporadic and minimal instances of violence, criminal activity that was appropriately handled by law enforcement at Portland is part of a greater whole. I think the district court found that the defendants did not present any evidence that the sporadic violence was part of an organized attempt to overthrow the government. And that's, I think, what they're asking this court to potentially look at when you're talking about, for example, the shooting in Dallas, that somehow increases the need.
Well, that goes to your rebellion, or that goes to their rebellion designation, but that doesn't necessarily go. I mean, you don't have to have that under prong 3, do you? For the enforcement of the laws.
Well, I'm sorry, I don't understand the.
Well, I mean, enforcement of the laws, you seem to say, well, there's no attempt to overthrow the government. And I mean, that's a fight within the context of whether there's a rebellion under subsection 2. But I don't know why that is relevant to subsection 3, which doesn't have anything to do with rebellion and is just the enforcement of the laws.
Well, I agree that the Dallas shooting shouldn't be the basis to send troops into Oregon. And if we're relying on that third prong, then it certainly, it doesn't make that more or less probable.
Can I add just, and maybe my colleagues have final questions too, but, and I don't want to focus on it, but I'm just perplexed. And I think Judge Beatty may have referenced this. So they reopened the building, they board the windows for protection. And what does the city of Portland do? They issue a zoning violation. Are you defending issuing a zoning violation, telling them to take off the boards that were put up to respond to protesters? Do you think that was maybe ill-advised?
Luckily, in this case, it's not something that the court needs to decide to determine whether or not the president's determination was within a colorable basis or within the range of honest judgment. But what we do know is that the circumstances at the time the president authorized the troops, whatever date that might be, they didn't raise to the level that was necessary under the statute. And we would ask that the stay be denied.
Any other questions by my colleagues?
No.
Thank you.
Thank you, Your Honor.
We'll have 3 minutes of rebuttal.
Thank you, Your Honors. I just have 3 quick points that I'd like to make. First, Judge Graber, going to your questions about the basis for the determination, we're not relying solely on the June 7th memo. My basic understanding is the June 7th memo was where the president sort of set out the framework and his understanding and interpretation that violence directed at ICE officers that seeks to impede their execution of the immigration laws is the sort of circumstance that can warrant activating the guard. And the president then subsequently made a determination that those circumstances were satisfied in Portland. If you look at page A52 of our appendix, you'll see that's where the DHS request is. DHS said that the facility in Portland and the ICE officers and the FPS officers have come under coordinated assault by violent groups intent on obstructing lawful enforcement actions. These groups have sought to impede through violent protest, intimidation, and sabotage of federal operations. That was the information that was before the president when he made this determination in September. Second point I want to make is about the language of the statute talking about a present inability to execute the laws. Because of the violence that's ongoing and the risk of violence that's ongoing, there is a present impediment to the execution of the laws because the forces are tied down addressing that risk. We've discussed the FPS officers. It's not just the FPS officers, it's also ICE personnel. If you look at page 85.
You have an answer to Judge Graber's question about how many FPS, there were 115 that were there in July at least, and maybe longer. How many are there? How many were there in September of the additional?
I do not know the answer. I do not believe the record speaks to that. The citation that the plaintiffs provide in their brief to say that some have gone home is document 4626. You'll have to take a look at it for yourself. My best recollection, I don't have that document at my fingertips. My best recollection is it referenced about 10 people going home. But it's not just the FPS officers. If you look at paragraph 16 of the Cantu Declaration, it says the situation has resulted in FPS having to rely almost exclusively on ICE special response teams for assistance in preventing the violent protesters from attacking immigration officers and the ICE facility. And he explains that their primary mission is to be out in the field, handling high-risk immigration enforcement operations. but they're now having to be diverted to protect the facility, becoming a drain on immigration enforcement as well. If you look at the Walmsley Declaration paragraph 20, pages A77 to 78, it is to like effect. The final point that I want to make is, although we do think the judge was clearly wrong to circumscribe the inquiry to what was happening in September, I think the district court also did minimize the violence in September. I just want to highlight a couple of documents that are in the record. One is that our supplemental appendix A2 to A3.
Counsel, are you now withdrawing what you said earlier, which is that you are not challenging as clearly erroneous any of the specific factual findings that the district court did make, as distinct from ignoring certain things?
I'm not challenging factual findings about what she said in terms of X event occurred on Y date. There may have been other events that occurred on other dates that she didn't address. That's not, I think, an issue for clearly erroneous review. But if you look at page SA2 to 3, this is on September 28th. This is one of the police reports. It starts out talking first about how a group of these agitators attacked 2 observers, breaking the driver's window and leaving one of them bleeding heavily from the face. And then it says there were 50 to 60 protesters outside of ICE at the time. Most of them were blocking the facility's driveway in anticipation.
I've read that document. I have a different question about it. Does that not post-date the final document on which you were relying as part of the call-up? And didn't that happen after September 28th? Is the memo from the secretary?
Right, and so that's that same day addressing.
Okay, is that the final document on which you rely? And I guess my question is, can you rely on any event that post-dates the mobilization to justify the pre-existing mobilization? In other words, let's say there's nothing that happens at all. This is a hypothetical. Nothing happens, but troops are mobilized, and 2 days later, there are terrible things that happen. Does that go back in time to justify, or does there have to be something at the time of the mobilization?
I certainly think this evidence is fair game because it shows...
That's not an answer to my question. Can you rely on later evidence to justify a prior authorization?
I think we can rely on later evidence to show that there was a colorable factual basis for the president's determination here, because it demonstrates the very kind of risk that can materialize at any time with this sort of violent crowd. But it's not just on the 28th. If you go back a week earlier on September 20th, this was at page A104 of our appendix. It says, another police report, FPS agents were busy tonight. There was a group of 50 at the facility. Again, once a marked car drives through, they will flip off, scream, and throw objects at the car, and in most cases run towards the car as if they are going to charge the car. FPS Will Turner called me throughout the night with info about black blockers assaulting people. I received a video from FPS about a report about a journalist who was assaulted by a black blocker with a large sword or stick. To be clear, even if these folks were still at ICE or nearby, we would not be able to address the call or make an arrest with the resources that we have. This is hardly the peaceful and sedate crowd that plaintiffs tried to make it out to be. These are violent people. And if at any point we let down our guard, there is a serious risk of ongoing violence. And at some point, the president is entitled, when his subordinates are telling him, we are overstretched, this is unsustainable, the officers aren't available to do their jobs, they're not available to surge to other places where we face violence. The president is entitled to say enough is enough and bring in the National Guard to reinforce the regular forces. We'd ask the court to grant a stay pending appeal as swiftly as possible.
Thank you. Thank you to both counsel for your arguments in the case. The case will be taken under advisement, and we'll respond as quickly as we're able. Case is now submitted.
All persons having business with the Honorable, the United States Court of Appeals for the Ninth Circuit will now depart, for this court stands adjourned.